This is the second day of the hearing of the appeal of Bresco and Lonsdale. We are hearing the appeal remotely because of the situation in relation to coronavirus. The details of the case are available on our website. I'm Lord Reed, the President of the Court. I'll be hearing this appeal together with my colleagues, who I'll just introduce now. Lord Briggs.
Good morning.
Lord Kitchen. Lord Hamblin.
Good morning.
And Leggett.
Good morning. If I wasn't heard, then good morning again.
Yes. Yeah. We began hearing this appeal yesterday when we heard submissions on behalf of Lonsdale presented by Ms. Sinclair, Queen's Counsel, and we also heard part of the submissions presented on behalf of Bresco by Mr. Arden, Queen's Counsel. Today we'll be hearing the remainder of Mr. Arden's submissions, and then we'll hear Ms. Sinclair in reply. We'll be sitting this morning from 10:30 till 1 with a short break mid-morning, and in the afternoon from 2 until 4 or earlier if the appeal finishes before then. So, without further ado, I'll hand over to Mr. Arden, Queen's Counsel, to continue the submissions on behalf of Bresco.
Lords, yesterday I'd taken your lordships through those parts of the insolvency rules which dealt with proof, and I was about to turn to the set-off rules. Lords, before I do that, can I just supplement what I said yesterday? Just 2 points for just for the sake of completeness. The first is this, that I mentioned or have referred yesterday to the provision which deals with appeals. That's Rule 14.8. Lords, your lordships probably know, but I should just remind your lordships that an appeal from a proof is a de novo hearing, and the judge who deals with the appeal deals with the matter afresh and on whatever material is then available, and so it's not confined to the material that was available to the office holder when the office holder dealt with the proof, and that in a sense is a reflection of the fact that it's accepted that the office holder, when dealing with the proof, may well not be in possession of all materials or all information that bears on the question of whether or not proof should be admitted, and if so, for how much. Lords, the second point I wanted to mention was this. Yesterday, I took your lordships to the various ways in which a proof could be varied or expunged or increased or reduced to take account of change of circumstances, or a necessary revision to take account of, for example, to re-estimate, for example, a contingent debt, and so on. So I'd describe what is an essentially fluid process. In terms of how that works with the insolvency as a whole, the position is this, that the office holder it's dealt with in two ways. The first is by reserving. So an office holder is required under Rule 14.39 to make provision for debts which haven't been determined and disputed proofs and claims. So in in what I've described as a sort of an essentially fluid process. At any given time, office holders have the power and indeed the duty to reserve, essentially to protect the position of a creditor whose proofs yet to be determined, or cases where the proofs of claim still remain disputed. Where a reserve hasn't been made, and in terms of dividends, the position is governed by Rule 14.40. And it's really this: if a creditor comes in late, or a creditor's proof is increased as part of the process that I've described, where dividends, obviously they're entitled, the creditor will be entitled to participate in the increased amount. But where dividends have already been paid, they cannot be disturbed. That's 14.41. But under 2, sorry, 14.2 and 3, it's effectively you participate in subsequent dividends and you're given a right to catch up so far as you can do. If it's gone the other way, and so if it's a case where a creditor's proof is reduced or excluded in its entirety under the provisions that I referred to, the position is governed by 14.44. The creditor is liable to repay. Now, the process will eventually come to an end, and the end will be when the final dividend is paid. So there is an end to the fluid process. It will be once the last dividend is paid, then there's no more to distribute, and that's the end of it. But essentially, up until that point, the position that I described yesterday remains relevant, and the effect is governed by 14.40, which I've just referred to. So those were just the 2 points I thought that I should mention. And if I could now just come on to rule, in this case, 14.25. Lords, this is page, well, it's the rules start at page 571. And this rule is at page 581 of the bundles. And this obviously is the winding up the set of provisions. Lords, as your lordships probably have seen and will know, the original rule 490 is in a very much truncated form. It's very much shorter than the rule that now appears in the 2016 rules. Substantial revisions were made in 2005, applied both to distributing administrations and to winding up. And specifically and importantly, one of the changes made by the 2005 rules was a provision which enabled the claims on the company's side, so contingent claims on the company's side against the third party, to be estimated and brought into the account. The position before, which is noted by Lord Hoffman in MS Fashions, was that was not possible. And so on the company's side, all contingent liabilities, unless the contingency had been satisfied, could not be estimated and therefore fell out of the account altogether. Lords, that's now changed, and I'll show you where that now appears in the 2016 rules. The 2016 rules, again, look rather different from the 2005 rules. And they also, to some extent, take account of the Court of Appeal's decision in the Couthing case. They have clarified certain matters relating to future debts and given effect to the Court of Appeal's decision relating to which dealt with the amount of the future debt that the company could recover, making it clear it's not the discounted amount, but the full amount less the amount set off. Going back then to so that's the as it were the statutory background. There has been development, and some of it has been substantial from the original 490. The essential provisions, or the basic provisions, are those which appear now in the 4 sub-paragraphs 1, 2, 3, and 4. If there have been mutual dealings, then an account must be taken, and then the sums set off, and then the balance, if there's a balance due to the creditor, it's provable. If it's owed to the company, it's payable. It's payable to the liquidator as part of the company's asset. So very much the same as it was, before. Now, if I could just stop there for a moment. In a sense, although, and I think Lord Hotham comments on it, although the notion of an account sounds fairly ancient, the concept is really a very simple one. You've got eligible debts on. You simply draw up, as it were, 2 columns. There's the company's claims on the one side, the creditors or the third party's claims on the other. You calculate each column, and then the set-off itself is simply is a simple mathematical exercise, deducting one from the other, and that gives you the net balance. Lord, as with any account, where the disputes will lie is not in the mathematical calculation. That's utterly basic. The disputes will all lie in the items. And as with any account, you sort of run through it. You may be able to agree some. You won't be able to agree others, and so you have to decide firstly whether there is a liability is asserted, and secondly its quantum. Now, so I'll come back to that in a moment, because obviously that's an important part of the appeal, understanding what the process is, although, as I said, I think it is fairly obvious. If I can just go back to the rules then and pick up then with sub-paragraph 5, so 1425.5, you'll see there how contingent debts, how contingent and future debts are then dealt with. If the balance is in favour of the company, and if a part of the balance, is referable to either a contingent debt or prospective debt, then it's not payable immediately once the balance is taken. It's payable in full when the debt becomes due and payable. And so the process, or what is envisaged by 5, or what you have to do with 5, is you just simply say, well, set-offs occurred, estimation or discounting has happened. That's given you the net balance. As I said, if the balance is in favour of the company, then to the extent that the balance arises in respect of, as I said, a contingent or prospective debt, then it's payable in accordance. It's payable only in accordance with the contract, the term, i.e. the contract. And so one sees there that in relation to those 2 matters, what the rules clearly envisage is that the underlying claims either do subsist, or they must be treated as subsisting for the purposes of ascertaining when the liability arises, when the third party's liability arises. your lordships will see there bracketed, well, actually it's the second set of brackets, in respect of prospective debts without being discounted under Rule 14.44. That is the way in which the 2016 rules have given effect to the decision in Countthing. As I've mentioned, the question there was whether discounting applied, not just for the purposes of giving effect to set off, but discounting had the effect of limiting the company's rights in respect of a future debt to the discounted amount, so that all that the company could claim was the discounted amount as at the future date, and that was that Court of Appeal held no, and that is now given effect to by the rules. The other thing your lordships will see is that this paragraph also deals with it caters for a case where there are a basket of claims on the company's side. And so it deals with a case where, for example, there's just a simple, a straightforward debt presently payable, but perhaps also a contingent debt, and perhaps also add into that a future debt. And what it envisages is, and it's necessarily so, is that you have to, as it were, unpick the account. You have to look at what was in the account and to identify the individual items within the account, and then appropriate whatever sum has been set off between those different items, in order to identify what part of the contingent or prospective debt is payable in accordance with with the contractual terms. And so again, you'll see, and this really goes to this. Sorry, Lord Leggett.
Yeah, sorry, Mr. Ron, I had my hand up for quite a while, so we weren't quite sure whether you don't have the images showing or whether you just hadn't been noticing them.
No, I'm really sorry. I'm afraid I was probably looking at a blank part of the screen. I'm so sorry.
No, well, I just wanted to check that, not that it matters.
I can indeed see you.
I just wanted to ask, what happens under 1425(5) if between the time when the calculation is made and the debt becomes due and payable, if it's a contingent debt, the contingency doesn't happen, let's say, or the position changes? Is it fixed to the amount as when the calculation is done, but you just wait in time, or ultimately it doesn't become payable because of something that happens in between? Does that alter things?
Lord, I was going to come on to that. It's exactly the same. It's exactly the same position applies here as it does in to a simple proof of debt. The power to estimate is given by it's 14.25(8)(a). Well, that applies to this process. The estimation provisions of 14.14, which I referred to yesterday, including the power to change, to adjust the estimate. Now, you're always estimating, the estimate is obviously always at the relevant date. That's the fixed date. But as with a proof, so in set-off, you can always revise the estimate to take account of whatever you know at the time at which it matters. Well, there is in Lehman's at first instance, I think there are other places, but but I'll check. I think it's around about paragraphs 242 to 244 of the judgment of Mr. Justice David Richards. There is an acknowledgement that this will be the case. He was dealing there with the set-off as between, on the one hand, the subordinated claims of the members of Libby, and on the other hand, Libby's contingent claim, as he had held the contingent claim of Libby against his members for a contribution, essentially, to any deficiency under Section 74. Now, ultimately, it was held that the Libby administrators did not, in fact, have a contingent claim under Section 74, but that doesn't matter for these purposes. The example is good enough to illustrate the point. The example still stands to illustrate the point that I'm making. But it's clear from those passages that this is a continuing process. And so a value had to be put on the Libby administrator's contingent claim, but inevitably that value would change depending upon the estimated size of any deficiency in Libby, and indeed the prospects that Libby would go into liquidation, because that was the point at which the Section 74 claim could be made. And as I said, there's a clear acknowledgement there in those passages that it's a continuing process. So it just really makes the point, but which is clear from, as I said, from the incorporation of the estimation provision, that you keep going, as it were. Lord, I was just going to just going on through the rule. Lord, 6 and 7 are just simply bringing over to the set-off provisions, the very wide definitions that are used in the context of proof. And so the attempt always has been to match the items on each side. So everything is to be, so far as possible, should be brought in on each side, every kind of liability. That's really what 6 and 7 does. And then 8, which I've just touched upon in late answer to Lord Legate's point. 8 then brings over into set-off the rules that apply to proofs in respect of certain types of claims. And so 1414 is the one that we've just been discussing. And then 1421 to 23. Now, your lordships will see that this applies only to sums due to the company. That's because they already apply to sums going the other way under the earlier provision. So this is just bringing them over, making sure that the same rules apply on each side of the account. And so the exchange, the mandatory exchange rules are applied, that's B1. The periodical payments rules are provided, that's 2. And then B3, the interest rules are applied. And then at C, 1444, that's the discounting rule, applies wherever there's a future debt. And so for the purposes of set-off, and for the purposes of ensuring that, if you like, there's like-for-like matching on the two sides of the account as at the relevant date, all these rules are brought over so that you are you're comparing like with like for the purposes of set-off. Now, The most important, I think, for the purposes of this hearing is the estimation rule. What's clear is that you're looking at you're looking again at this rather fluid process. It's not necessarily going to be once and for all. There may necessarily be revisions. That's not to say that the account isn't final when it's final. It just means that it can be changed. Now, if I can just deal with this purely in a proof context for the moment, and then I'll turn to deal with it in other contexts, in other contexts after that. Lords, essentially, the points where the office holder is dealing with it, the points that I was making yesterday about the way in which the office holder approaches the accounts are equally applicable here. This is just a process of the office holder trying to identify what items are properly to be allocated to each side of the account and what value is to be attributed to them. No process, the rules don't require the office holder to adopt any particular process for those purposes. The object is to give, the object is to make it's clearly to get the most accurate figure reasonably possible in the circumstances. And for that purpose, the office holder is entitled to use whatever tools are available to him. Yesterday, I'm sorry, it can also be done. It doesn't have to be done at one go, in the same way that the proof process doesn't have to be dealt with in one go. It can be dealt with in an iterative way. Now, in order to undertake that process, the sorts of tools that that an office holder can use obviously include recourse to the court if necessary, but they also include, as they do in the proof process, any other form of process, contractual or whatever, which is available. And so there is no, in our submission, there is no impediment, no prohibition on using, for example, any contractual dispute resolution process to determine, say, single items on the account, if that seems like an appropriate way to proceed in the circumstances. And if one could take, if one could just take, for example, adjudication. Now, learned friend pointed out, and I accept, that there are many different types of adjudication, in the sense that adjudication can be directed at many different things. Now, if one takes, in the context either of a proof or indeed of set off, one possible way in which adjudication could be used is this: without asking the adjudicator to take any sort of account at all, there could be a dispute, for example, about the value of a particular set of works. And that could be, for example, a matter of hot dispute between the two, as it were, the two sides of the account, as indeed it could be in a proof process. Now, there's absolutely no reason in our submission why an office holder could not look at that and say, well, here's the matter, it's hotly disputed. I need the figure as part of the process that I'm undertaking. Adjudication would be a sensible way of dealing with it. You simply take you identify the dispute and refer it to somebody who's eminently well qualified to deal with it. And in that way, you get a figure which advances the process, even if it doesn't provide you with the full answer. It gets you some part of the way there. So that's just simply, if you take a sort of one example, an example of just a limited adjudication, that would be one way in which this could be used. And in my submission, there could be no objection to it. Now, equally, we've said in relation to we've submitted in relation to proof, and we submit in relation to mutual dealings. You could do the same in relation to either where it's a multiple contract case. You could say, well, it would be useful for me to know what the value of each individual contract is, or what the value of the claims are in relation to each of those contracts, and seek and will refer those to adjudication. Again, it's just a way of fixing a figure, and bearing in mind that this is a dispute resolution process. It's one where you can it's a process that you can reasonably embark on, and have reasonable expectations that the process will be successful, in the sense that it provides a figure, and a figure which is acceptable to both sides. And in that way, you avoid a larger and more expensive dispute, for example, by going off to court or the TCC, either the court for directions or the TCC for determination. If early neutral evaluation is an option, again, there's absolutely no reason, maybe every reason, for employing it. This is just all about trying to arrive at figures, and they can be a part of the process. They can be the whole of an item, or if you're looking at a case like Bresco, it could be the whole of the dispute. Now, well, that's obviously a matter of which I'll return to when I'm dealing with the points that learned friend makes about the incompatibility of the two processes. But can I just I just want to deal with this point, which arises out of the arises in relation to the set-off provisions, and that's this: the set-off will leave you with claims valued as at the relevant as at the relevant date, and a net balance. And I've shown you why it might be necessary to unpick that to enable you to identify what parts of the net balance are attributable to what. Now, what the rules don't deal with are the other rights of the other rights of the company, in particular, in respect of the debts that have been included as items in the account. And if I just give you this example, which is count thing. Assume that you've got a future debt which bears interest. The question arises as to whether or not the company would be entitled to claim contractual interest on whatever is due to it, up to the date on which it becomes due for payment. In other words, does the company's right to interest continue after set off? Now, that issue was dealt with at first instance in count thing. And you can see it in the Court of Appeal in count thing, dealt with in the Court of Appeal in count thing. And I think this is worth turning to. It's at page, count thing is at page 886. And if I could pick up in the judgment of Lord Justice Etherton, if I could pick it up at paragraph 15, and just ask your lordships to read 15, including the passage from Mr. Justice Norris's judgment, and then over to 16. I think your lordships will have, so your lordships will see, I think, see the point. For the purposes of set-off, the future debt is discounted back. The future debt is discounted back, and it's given a value as at the relevant date. The question then arose as to whether or not it had continuing rights to interest. Whether it could claim contractual interest up to the date of payment. There's a second question as to on what amount, but the point here is whether or not the right to interest, whether it survives or whether it's extinguished by the operation of the rule of set-off. In other words, have the contractual rights been extinguished so that there is no longer any continuing right to contractual interest. And you'll see the way the judge dealt with it, which is to say no. And essentially he echoes preempts what Lord Justice Etherton then said about the policy of the Act. He said no, you set off and you get your net balance. But set-off does not then prevent you from relying on your contractual right to interest on, as he held it, on the net balance. And then the issue was what the net, then the separate issue was what the net balance was. But what you can see from that is and he was addressed on Steen and Blake in this context. And what you can see is his what you see then is his conclusion. Well, no, the underlying right remains, and indeed we see that reflected in the rules. The underlying right remains, certainly at least for the purposes of enabling the creditor to rely on its contractual right to interest over until the date of payment. And Lords, that's then picked up in the judgment of Lord Justice Etherton at paragraph, you can see it's picked up at paragraph 37. And this is all part of this is in that part of the judgment which deals with the point before the Court of Appeal, which is whether the discounting provisions meant that the count thing could only claim the discounted amount. That was the total of the debt that it could claim on the date on which the debt became due. You'll just see that, so Mr. Fisher for the depositors was saying, was deploying Steen and Blake in support of his submissions that only the discounted amount was due and not the full amount less the set, and not the full amount after less the amount to be set off. In support of that and in mitigation of what was seen to be a clear injustice to the company, an extraordinary result, Mr. Fisher had relied on the fact that the judge had held that interest was payable as justifying the commercial effects or what appeared to be the commercial rationality of the conclusion that the judge decided that he had to come to on what the principal sum would be due. You'll see that it's simply noted that the decision that Lord Justice Etherton simply points out that there is a difficulty for Mr. Fisher because he's relying on a decision which was based upon an analysis of Steen and Blake, which was inconsistent with the analysis that Mr. Fisher was running on the main point in front of the Court of Appeal. There is nothing in that paragraph, noting Mr. Fisher's difficulty, there's nothing in the paragraph which undermines or suggests that Mr. Fisher suggests the judge was wrong. There's no endorsement by Lord Justice Etherton of that submission. And if one steps back and asks oneself this, well, could it be right that the effect of set-off is to extinguish the company's contractual right to interest? The answer must surely be no. There's no justification for that. That's not consistent, not required by the policy that underlies the rule on set-off, which is identified by Lord Justice Etherton earlier. Lords, one can see the same point arising in different contexts. And so take this example. Set-off applies to secured debts. And so imagine a case where you've got a security which secures repayment of a debt which is identified by reference to a particular facility. So not all money is due or anything of that nature, but a security with a debt specifically identified. Now, set-off will work, and set-off undoubtedly works, to reduce, if it exists, to reduce the amount of the secured debt. And so, well, the point is obvious, the debtor can use set-off effectively as a part payment of the secured debt. That's the sort of conventional way in which it's described. But an over-literal or an over-enthusiastic application of Steen and Blake might lead to the argument, might be thought to lead to the argument to the effect that, well, if set-off applies, then the debt is gone, and then there is nothing secured. And again, that can't be right. And so again, the answer must be that it must be, as it is with interest, that whatever application, whatever effect set-off has, it cannot operate so as to discharge the debtor from rights, as I said, such as the right to interest, or in the security case, its security. Now, I've dealt with that. This is an attempt to deal. I'm sorry, Lord Briggs, I think I...
One short question, Mr. Arden. Is there, I can see that part of the decision, or the main part of the decision in Coupling, is now enshrined in the 2016 rules, as you showed us earlier this morning. Is there any judicial or academic consideration of the question whether any other aspects of the Coupling analysis, including the one about interest, which you've just shown us, is in any way affected or undermined by the decision of this court in Lehman Waterfalls? I mean, don't answer on the Kahoot if you don't want to, but if there is something, it would, I think, be of assistance to me at any rate.
Yes, I couldn't find anything. Lord, I looked. I mean, Your Lordship obviously has in mind it's the debate in the Supreme Court about about reversion to contract and the relationship between the statutory regime and parties' underlying rights.
You may say it sits. You may say it sits on my heart, Mr. Arden, rather like Calais did on Queen Mary's.
Well, Your Lordship dealt with it very gracefully in the Court of Appeal in Burlington and Lomas. But it is the same point, and it is the continuing debate, and it's a very interesting. It is a very difficult one. Lord, I had thought about this. Well, obviously I thought about it, but the difference between it's not a perfect difference, but a very significant difference between those cases which obviously deal with the mandatory conversion and the statutory interest regime. The difference between those cases and this is that those are cases which particularly concern the rights of creditors against the company. I don't say that that is a complete answer to the point, because obviously mutual set-off deals with claims in both with claims in both directions. But
Can I just say, I'm not really asking you to go into detail on this because it's at a fairly tangential corner of today's analysis. But if there was some material on it, it would just be helpful to know about it.
We will look again. As I said, I wondered whether there was more material that might help, because this is part of this. It may be tangential to this appeal, but it maybe is a part of a larger debate, and a very interesting one, quite difficult.
Thank you.
This is really, but what this is essentially directed at, you Lordships will understand that what I'm directing this to is, as I said, it's what I think may be the submission that I have to deal with, which is that because the underlying claims have gone in their entirety, it means that there cannot be anything that could properly be the subject matter of an adjudication. And my answer to that at this fairly general level, I think it can be dealt with in a slightly different and more confined way, and I'll come on to that in a moment. But my answer to that at this general level of principle is this, that one can see, both from the rules and from particularly CalcThing, and from the examples that I've given, that set-off cannot be taken to have destroyed all other rights which exist, all the other rights which exist, all the other rights which exist, importantly, including the purposes of this case, the right of a party to refer to adjudication. And that would, in my submission, be consistent with what I think is accepted by Lonsdale, which is that an arbitration clause, which is in identical terms to Section 108, would similarly survive, and well, an arbitration clause would survive, in that form would survive and would be available. I've dealt with set-off in the context of the proof process, and I said yesterday, I'm sorry, Lord Leggett.
Yes, I may be jumping ahead, Mr. Arden, you may be coming to this, but in Steen and Blake, Lord Hoffman talks about claims continuing to exist for some purposes and not for others, which may be thought not terribly illuminating by itself. Is the policy justification for Steen and Blake that if the underlying claims could be assigned and not just the net balance, that would sidestep the insolvency set-off, the purpose of the regime, by allowing the person for whom the claim was assigned to pursue the whole claim rather than just the net balance? So I may not have explained that very well, but you see the point I'm making. Or can it not be justified in that way?
Certainly, Steen, what matters, I mean, it is important when one's looking at Steen and Blake to look at the context, the context in which the issues arose, and indeed the arguments that were being made. As the Lordship says, the context was an assignment by the trustee, and the assignment was of the whole cause of action. And so the assignment purported to assign a claim, a gross claim, if I can call it that, and not the net claim. And that plainly doesn't work, and we wouldn't for the moment contend that it works because of the nature of set-off. It could only ever have assigned the net balance. So because set-off, if it existed, had already occurred. Now, the arguments it is interesting to look at the arguments, because what was being said by, so Mr. Marks for the debtor defendant, his argument was that the account had to be taken by a trustee. It was a non-delegable duty. It had to be taken by the trustee. And until it had been taken, there was no net balance and therefore nothing to assign. And so that was the position on one side. Mr. Bannister, for the assignee, presumably concerned about the language of the assignment, argued that the effect of that the assignment of a gross amount was perfectly valid. You could assign the gross amount, and then it would be subject to equities, the equities including insolvency set-off. And so he was arguing for his argument was premised on set-off having essentially a procedural effect. You just give it, it takes effect when you give it effect. And arguing also that, and sort of it's a continuation of this argument, that what's the way that set-off works is not by payment, as it were. You don't treat it as payment. So it doesn't have substantive effect. What it does is give you a defense. It's a limit, it's a restriction on enforcement. And I think the way I've read it is the reason he did it, as I said, is that he was concerned about the terms of the assignment. Now, that is what Lord Hoffmann is. That's the context in which Lord Hoffmann is dealing with these issues, and what he points out, he makes and in order to deal with it, he then has to analyse the substantive nature of set-off, and the concern always is the notion that you can somehow. Or the concern is always that by assignment you can essentially defeat the operation of set-off, and the way in which you deal with that is by understanding what the substantial effect of set-off is, and when it takes effect, and as from what date. And once you've done that, it follows that Mr. Bannister's argument is plainly wrong. because you can set off having occurred, even if you don't know it. All you can ever do is assign the net balance, whatever that is. Net balance, and then the question is the net balance, is what one's talking about there, the net balance of the claim, sorry, the net balance of the claim, which is the way in which many judges have described it, or is it some new statutory debt? Now, it is quite instructive in the context of this dispute, actually, to see the way in which he dealt with the validity or the construction question. Let me just have a quick look at this. Page 1297. And if I can just use the report page, it's page 258 of the report, and it's at H. And you'll see, did the actual deed executed by the trustee, so that's of the entirety of the cause of action, have the effect of carrying the net balance? That's a question of construction. If a trustee purports to assign the bankrupt's rights in a cheque for £10,000, it would be absurd to hold that the deed has no effect, because it turns out that the drawer of the cheque has some small counterclaim against the bankrupt. The intention is clear enough. If it would have carried the original cause of action, it will also, as a matter of conveyance, carry the right to the balance after deduction of the cross-claim. I can stop there. Now, it's one of those sort of classic cases where poor Mr. Marks, sort of having won most of the, or quite a lot of the major battles, then lost the war on a question of construction. But if one sort of thinks in terms of destruction of causes or extinguishment of causes of action, if the cause of action has been extinguished by the operation of set-off, it doesn't really sit very well with that approach to construction, because if it's gone, and all you've got is, or what all you're assigning is some new statutory right, then you're not assigning the lesser of the greater, you're assigning something completely different. Lord Hoffman's approach on construction is to deal with it in terms of the lesser of something bigger. Even if you can't assign the gross, you can assign the net. Lords, the absurdity point there is, it's one that it can be deployed in wherever this debate arises. It can be deployed in this case, perhaps with more force. The consequence of, if my learned friend is right, then a £5 cross-claim will destroy, or may be taken to have destroyed, the underlying right to adjudication, have whatever consequences also follow from this notion of the extinguishment of claims. Lord, in a sense, it's worse than that in this case, because my learned friend's case, Lonsdale's case, is that this occurs not merely when you know that set-off is engaged because there are items on both sides. It occurs simply by the assertion of one or other party of a genuine cross-claim. So before you've even taken the account, if you simply genuinely assert a cross-claim, it has this effect. And again, there are different ways of avoiding the absurdity. One is, as I said, not to take the extinguishment of claims analysis too far, but to restrict it to its proper context. The other is by using the other technique, which is you simply say that the claims are treated as continuing to claim for the purposes of giving effect to the party's other rights, for example, interest, security, and so on and so forth. But I was then just going to move on and deal with other circumstances in which, or the other contexts in which set-off may come to be dealt with. And in a sense, this is relatively straightforward. Lord Hoffman provides the very short answer in Steen and Blake. If your lordship still have it, it's at 253, the occasion for taking the account. It starts with in what circumstances must the account be taken, and he starts with the image that the rule invokes, and actually that is the way it would have been done in the early 19th century. This would have gone before the bankruptcy court, which then administered bankruptcies. The sort of notion of office holders and the delegation of the court's duties to trustees and liquidators was a later 19th century development. Originally, you would have turned up before the commissioner sitting as the bankruptcy court in Basinghall Street and then had the debate there. But obviously that's no longer the case. But he said the taking of the account, sorry, I'm going back to Steen and Blake, is no more than the calculation of the balance due in accordance with the principles of insolvency law. And then he said the obvious occasion is the proof process, and I've dealt with that. But that is not the only circumstances in which it will be done. And you'll see there in that paragraph the analysis of the words any creditor of the bankrupt proving or claiming to prove for a bankruptcy debt. Long held understanding, sorry, and it's those words, and it's particularly claiming to prove, are construed as extending. So it's any creditor apart from mutual settle would have been entitled to prove. Thus, the account can be taken in an action by a trustee against a creditor who hasn't proved. So the starting point is the proof process, but the words of the section are wide enough to embrace a case where you have a non-proving creditor who would be entitled to prove. And there you've got the two sides of the account. Now, when does it come to be taken? And then this is what he deals with in the second paragraph. Once you've eliminated the need for a proof, it's not linked to it's no longer linked to any step in the procedure of bankruptcy or litigation. He contrasts that with legal set-off. The account must be taken whenever it is necessary for any purpose to ascertain the effect which the section had. Now, Mersey, Steele, Peaton, Jones, those sorts of cases, these are all cases where the office holder of whatever type, either itself, if it's a trustee in bankruptcy, or via the company, if it's a liquidator prosecuting in action the company's cause of action. It can arise in ordinary proceedings of that nature, where, as I said, the trustee or liquidator seeks to enforce the cause of action. And then the defendant sets up by way of defense and cross-claim insolvency set-off. So that's one context. You know there that you're going to have to do it. It's a necessary occasion on which you have to give effect to mutual set-off, because it's concerned with ascertaining what is due from claimant to defendant. But that's not the only case in which it can happen. And you can see that from the discussion of Guy and McIntyre, which were proceedings which necessarily involved the court deciding what the position was between two parties, but which had nothing to do with which had ceased to have anything to do with the insolvency process. It was understanding what effect the insolvency process had had on a claim now vested vested in different parties. Another context in which it can arise is an action for specific performance. And so re-night, which is referred to in some of these authorities, was that sort of case where the claimant claims specific performance of a contract for the sale of land as against a trustee in bankruptcy, and sought to set off against the price set off, and was entitled to do so. And you can see it in a redemption action, which is Barnett, which again is one of the cases, classic cases in this case, an action for delivery up of goods subject to a lien on the basis that the sum secured by the lien had been discharged by way of settlement. All sorts of different contexts. In the context of ordinary proceedings, where to use the words of Lord Hoffman, it is necessary to ascertain the effect that the section had. In other words, to strike the balance, to understand what the balance is. Now, you'll have seen, your lordships will have seen in this case how the problem about the substantive effect of set off is dealt with. What is the answer to the claim? And so Mr. Mark's claim is that, well, you've got no cause of action. You've lost there's no cause of action in those cases. What are you suing for? It's gone. And the answer to that is provided. It's provided in MS Fashions and Steen and Blake, which is that you simply treat for the purposes of those proceedings, you treat the causes of the underlying causes of action as subsisting. So, and by treating them in that way, you save as it were, save the cause of action, or you give a cause of action which would otherwise have been lost. Now, Lords, if I can then move from ordinary proceedings then to arbitration, where exactly the same problem arises and exactly the same solution applies. And so even we're now looking at a very limited area. What is the answer? Why is arbitration? How can it work? Short answer is because the underlying claims are treated as continuing to subsist for the purposes of the proceedings in which the account is being taken. And if that is correct, then it is in our submission barely a step to the conclusion that exactly the same point applies to adjudication, where the adjudication is an occasion on which it is necessary to take the account. Now, not every adjudication falls into that category, and I gave as an example a very limited adjudication, which was simply involved with the valuation of an item. Now, that doesn't require you to take the account, because you don't need to understand or to reach any conclusion about the underlying balance or the overall balance between the parties in order to answer the question. But there will be adjudications where the account must be taken, and that will be essentially the final, particularly the final account type adjudication, which seeks to determine the parties' respective rights in their entirety. In that sort of case, of which this may well be one, depending upon Lonsdale's response to the referral notice. In that sort of case, that will be an occasion on which the account must be taken, because because you need to understand, or you need to give effect to set off. You will need to give us effect to set off because it's mandatory. Then in that event, the treatment provisions which save proceedings and save arbitration, or found or justify the proceedings, form the basis of proceedings and arbitration, so also form the basis for adjudication. And that's consistent in my submission with the submissions that I've made on the wider context in which this issue arises, which is that which relates to how you treat or how you deal with the party's other rights that are not that are not needed to be as it were, extinguished for the purposes of set off. Lord Briggs, yes.
You said a little while ago that you avoid the absurdity of the type referred to by Lord Hoffman in Stein and Blake, of a tiny cross claim destroying your rights in relation to a much larger main claim, either by not taking the new debt point too far, or by equating a right to adjudicate with rights to security or interest or rights to arbitrate. Is another possible way to deal with what would otherwise be the absurdity to keep a distinction in your mind between claims and disputes? By which I mean it's easy to understand that in Stein and Blake the effect of the set-off is to substitute old claims going in opposite directions with a single net claim for new claim for the balance. But to get at the answer to the question, which way does the balance go and for how much, all the old disputes about the old claims remain live for the purpose of that determination. So the claims may go, but the dispute don't.
Lord, yes, that is another way, and I think it's Lord, it's consistent. I think with it's the same position. I think I'll probably be corrected if I'm wrong. It's the same position in arbitration, that you don't need to characterize what you're trying to refer to an arbitral tribunal as a claim in order to give the tribunal jurisdiction. The term disputes is much wider than that, and so you wouldn't necessarily need an underlying cause of action. That's far too restrictive. So, Lord, yes.
Thank you.
I've reached this is a convenient point, and I think Mr. Shaw reminds me it may be time for a 5-minute break. So if this is convenient to your lordships.
Now for about 5 minutes. But before you resume your submissions, Mr. Arden, can I just pursue with you the point that Lord Briggs raised a moment ago? As I understood what Lord Briggs was suggesting to you, he was focusing on the balance due on the taking of the account.
Excuse me, Lord Reid.
Yes.
Are we supposed to go live at the moment? Are we okay to go back?
Yes. Could we go live in about 10 seconds or so?
10 seconds would be fine. Thank you.
I think we're ready now to resume the hearing in the appeal of Bresco and Lonsdale. Mr. Arden, Queen's Counsel, is in the course of his submissions, and if I may, I'd like to pursue further with him a point which he was discussing with Lord Briggs just before we adjourned. As I understood what Lord Briggs was putting to you, Mr. Arden, he was focusing, I think, on the balance which would be due on the taking of the account required by Rule 1425, and suggesting that if that were in controversy between the parties, then that would be a dispute which was a dispute arising under the contract and therefore capable of being resolved, capable of falling within the ambit of an arbitration clause or an adjudication clause. Now, as I understand it, the way you've been putting your case so far has been rather to focus on the claims and on what we're told in Steen and Blake, that the claims have to be treated as continuing to exist for the purpose of settling the account. And saying in that case, well, Steen and Blake itself makes it clear that the balance can be established by the company bringing proceedings in court to enforce its claim, and any matter arising in set-off being raised by way of a defence. And you suggested that if it can be done by litigation, then in principle, provided you're within the ambit of an arbitration clause or an adjudication clause, then it could equally be done by arbitration or adjudication. Am I right so far?
Well, Lord, I think what I think Lord Briggs raised with me is this: that it's not a dispute about the net balance, because that's just a mathematical calculation. Yeah. Part of the dispute, well, I think Lord Briggs is.
Can I just say that Mr. Arden has correctly understood, even if I didn't put it very clearly, the point that I was making. I was treating the disputes under the old claims as surviving the absorption of the claim itself in a set-off process, because those disputes still had to be sorted out before you could do the mathematical calculation necessary to produce the net balance.
Yes, well, that reassures me. My concern was that if you focused on the balance, then the balance might involve all sorts of items that had nothing to do with the contract. But if you focus on the claims, then it's easier to see how they can be brought within the scope of an arbitration or adjudication clause.
Yes, I mean, I suppose it may happen that a particular set-off arises between claims and cross-claims, all of which are under the same building contract.
Yes. Right.
So subject to the single dispute rule and working out whether there was therefore one overall dispute, they could all be adjudicated or dealt with in an adjudication. Yes. But I have a problem, which I hope Mr. Arden can help me with, which is what happens where the dispute about the claim is within the scope of an adjudication provision, but the cross-claim arises from some entirely unrelated mutual dealing, which has nothing to do with a building contract at all, and might involve some completely different form of expertise, but is nonetheless, at least in theory, available as a set-off by way of defence. How does the poor adjudicator work out what the value of that defence is if he's being asked to adjudicate on the actual net balance? My instinct is that he can't.
Your Lordship's absolutely right that if the example is perfectly possible, and one can think of lots of different ways of putting it, but you're absolutely right that set-off could involve a claim completely unrelated and completely outside the expertise of the adjudicator. Now, the adjudicator would, because the adjudicator has to apply the applicable law and has to give effect to a defence, you could have a situation where the adjudicator was essentially required to do something for which, as your Lordship points out, he may be completely unqualified. Now, Lord, there's no perfect answer to that. There's a practical answer, which is that in a case where you can see that there is a real possibility, and it needs to be a real possibility, that an adjudication is not going to work because the adjudicator might be required to, there may be an item on one side of the account which could be a personal injury claim or something like that. One can take any sort of, not Leggett.
Surely the adjudicator can only determine a cross-claim, if you like, if it can be set off and provide a defence to the contractual claim, because the adjudicator doesn't have, his jurisdiction doesn't extend in any shape or form to the personal injury cross-claim.
Well, that might be an answer, but what the difficulty, I think, the way, and because of this underlies the way in which I put it a few minutes ago. What one can see, if the adjudicator has to apply the applicable law, and if the applicable law has a mandatory, there's a mandatory set-off provision, then that might be the way in which he might found his jurisdiction. He simply has to deal with it. But I accept, and I know this arises in other contexts, that it could separately, there could separately be a jurisdictional issue of the type that I can see how the argument would go that if there's a dispute, that if it involves a dispute which falls outside the jurisdiction, if the defence involves defence involves a dispute which is outside the terms of the adjudication provision, then his jurisdiction can't extend that far, and the requirement,
that wouldn't be a dispute under the contract.
Exactly, and then the requirement that he apply the applicable law and the mandatory parts of the applicable law wouldn't save it, as it were, which I think was where I started. Well, that might be the way. That might be the way in. But either way, I can certainly see that whether it's it's likely always to be hypothetical. Certainly, the more extreme the case, hypothetical simply in the practical way that I suggested a few minutes ago, which is that it's very difficult to conceive how a liquidator acting rationally would try to have adjudicated a claim which the adjudicator was simply totally unqualified to deal with. Roderick, yes.
Yes, I'm just pursuing the point further. If you have, as you've put it, the two columns of debts on one side and debts on the other, and if you have debts which fall outside the contract, for example, personal injury claim, then clearly the adjudicator couldn't adjudicate on an item of that kind. So he would simply be dealing with whatever items fell within his contractual jurisdiction. Now, it may be that the consequence would be that the contractual enforceability of his award would be overridden by the operation of Rule 1425. You couldn't get a summary judgment to enforce the sum which he had found to be due under the contract. But you would, I suppose, what you could say is that it might still, depending on the circumstances, it might still be a convenient way of establishing and quantifying the items that he was able to deal with.
Well, that's right. I think this is a sort of an extension of a point I made earlier, where I said, well, you could adjudicate limited, you could do limited adjudications, which might still be useful. I gave as an example a very limited one, which is just, can you evaluate what's the value of these works? And set-off simply doesn't arise because you're not asking the adjudicator there to tell you what the final position is as between the parties. Now, in a case, if you've referred more, if Lord Reed's example, if you've done more and say referred a complete contract or a complete contract or it's a complete contract to the adjudicator, but it turns out that there are other matters that need to be taken into account but can't, then you've got what you have there is an occasion upon which the account can't be taken. It can't be taken and doesn't need to be taken, in the words of Lord Hoffman. So you haven't got to the occasion where you can, where the adjudicator needs or can settle the final account, as it were, sort of identify the final account. Now, in practical terms, what that would mean is that, and adjudicators obviously have discretion as to the way in which they frame their relief. In practical terms, what that would result in is it's effectively declaratory. It would be a form of declaratory relief, and so the adjudicator wouldn't make a money award, but simply say, in relation to this contract and this contract only, this is the position. And in that way, the position under that contract is settled, which is obviously beneficial to the process, but not settled but settled only in the limited in the way in which I've suggested, which then leaves it over to another occasion to deal with the final balance, whatever that further occasion might be. And so in no way prejudicing or undermining whatever rights set off the other party has. That's really the critical point, is that when it has to be done, then it needs to be done. But it's really the same, almost the same points that I was making yesterday. There can be a road to that with to mix metaphors, but it's a number of stages. And what you need to do is to ensure that each stage doesn't preempt the outcome. And actually, well, thinking about it, I mean, this is exactly Aztec, because in Aztec, Balfour Beatty and Aztec, this is multiple adjudication. This is 3 or 4 adjudications under 3 or 4 contracts, but the same adjudicator. And Justice Waxman's approach was, well, that is not a problem, because the occasion upon which the account, there will be an occasion upon which the account has to be taken, and that will be the enforcement stage. And so, on the footing that all 4, as it were, all 4 results are then listed. The enforcement of all 4 results are listed before the same judge, which would be necessary. It would be that judge who then comes to do what Mr. Justice Waxman described accurately as essentially the mathematical exercise. Lords, what I was going to do now is just run through the other points that my learned friend makes about adjudication. Now, there's obviously a large overlap between that and the injunction issue, and I will be able to take the injunction issue pretty quickly. I would hope I would finish at lunchtime, which is, I think, the end of my allotted time. Now, Lord, so far as this, I'm really picking up now on it's really paragraphs 46 to 63 of my learned friend's skeleton. These are well, the correct approach to construction of the Act. Sorry, that's, yes. Some of these I think I've already dealt with, but construction of section 108. There's there at paragraph 46 of the skeleton, that's page 3013. She uses she identifies or characterizes the insolvency set-off process. And that's simply taken from the judgment. And in our respectful submission, I think for the reasons I've already given, that is, with great respect, not the right approach to, or not the right characterization of what is required by the rules. It's much more the process, the process to which I've referred. There is then on the meaning of the word dispute at paragraph 50, there's a reference to Hillcrest Homes and Fiona Trust. Now, there are massive judgments about the meaning of the word dispute, not all of them easy to reconcile with the others. But in terms of general approach, is Fiona Trust applicable, or is some version of Fiona Trust applicable so that you adopt it in a liberal and not over literal manner? In our submission, the answer is yes. Essentially, for the reasons given by him, given by sort of Aikenhead in the case to which my learned friend referred yesterday, which I think is Murphy, and that's page, I think page 916 of the authorities bundle. Your Lordships will recollect that learned friend referred to Hillcrest, where there is a very short statement about Fiona Trust to the effect that it was submitted that Fiona Trust didn't apply because adjudication was essentially not a consensual process. And the judge dealing with it very shortly by saying, I see force in that submission. There's a very much longer consideration of this. Sorry, I'm told, I think it's 869. I've got completely the wrong reference. Yes, it is. Sorry, it's 869, and it's the passages essentially starting at 16 and going onwards. And you'll see there a very full analysis there is a very full analysis of the authorities, and indeed of the reasons why an approach analogous to that adopted in relation to arbitration agreements should be adopted in relation to adjudication. Well, essentially, we respectfully submit that Sir Robert Aikenhead's approach and reasons are entirely correct. Now, my learned friend submitted that this was dicta. Now, I think if one just simply looks at 869, which is the head note, I'm not sure she's right about that, because the question was whether the particular dispute was under the contract for the purposes of section 108. And one can see that just above the holding. The claimant contended that while the dispute as to the final settlement arose in connection with the subcontract, it did not arise under it for the purposes of section 108. So that is the question he's addressing. And then applying, on the question of construction, applying the Fiona Trust approach. Now, paragraph 53 of my own friend's skeleton, and it's useful, I think, to bring this in at this stage. Lonsdale contends that there is a comparison to be drawn between arbitration and adjudication. Now, some of her points we don't particularly dispute, the sort of nature of arbitration, the nature of the result, and so on and so forth. But one of the points that's made at various stages is this distinction between the consensual nature of arbitration and the mandatory or imposed nature of adjudication. We respectfully submit that distinction, the distinction is wrong and in any event unhelpful. For these reasons, describing arbitration or characterizing arbitration as universally the process of the product of consensus is wrong, because many arbitration clauses, like the adjudication clause, will be imposed as a condition for participation in a particular activity. And just to use a simple example, but a real one, if you want to be a racing driver, you enter into a Formula One racing driver, you'll enter into a driver's contract with your team. But in order to participate in Formula One, the driver's contracts have to comply with the rules that are set by the governing body. And one of those rules requires the driver's contracts to have an arbitration clause. And one can think that's a very simple example, but it's quite similar to adjudication. It's the price you, if you like, it's not really a price, but because I think that downplays the advantages of dispute resolution. But it shows that you can have to agree, you may need to agree to a dispute resolution process simply as the price, you may need to agree, or arbitration could be characterized, an arbitration clause could be non-consensual in the same way as adjudication, simply as a price, the price you pay for participation. So that just the distinction is wrong. In any event, and this I think picks up on a point that Lord Hamblin made yesterday to my learned friend, construction contracts may well contain bespoke provisions in any event. And if they do, the adjudication provision clearly stems from a contract which they've negotiated and entered into. Is there, I ask rhetorically, then a difference between an adjudication provision which is bespoke, as indeed is the case here, and one where the parties simply opt in willingly or otherwise to the default provisions of section 108? if the background to adjudication is, as I understand it, that it's essentially a form of, or that it was seen by the Latham report as being essentially a matter of best practice and was already in existence before he made his report in this and to a greater extent in other jurisdictions. And he regarded adjudication as a form of dispute resolution which would be beneficial to the industry as a whole, and thought that it was right as a matter of best practice that contracts should adopt it. Now, given that background, it is in my submission reasonable to suppose, particularly given the nature of adjudication, it's bilateral. It's not a one-way provision. It's bilateral and intended to benefit both parties to the contract and indeed all participants in the industry. Given that, even in the absence of Section 108, one would have thought in the current climate that many clauses would have, many contracts freely negotiated would have it anyway. And so if one's really looking at the sort of non-consensual nature of the inclusion of the clause, does it become necessary to ask in relation to each contract, well, what would you have done but for Section 108? But then that's an absurd inquiry to make, because it requires a difference in approach to depend upon a sort of subjective inquiry as to what the parties might have done absent Section 108. And so in our respectful submission, there is no distinction, and no distinction that can be drawn upon the sort of non-consensual nature of adjudication. It's wrong. Quite apart from that, we would respectfully submit that a lot of the points made by Sir Robert Aikenhead in Murphy about the desirability of incorporating the approach in Fiona Trust are equally applicable, consensual or otherwise. It is absurd it's absurd that the outcome in relation to jurisdiction can end up turning on a tiny difference in words, the inclusion of words arising out of, on top of or under, and so on. In a sense, when you look at the point that Sir Robert was having to deal with in Murphy, it sort of demonstrates the point that there is some difference between under or in connection with. And so all of the reasons why those sorts of distinctions were considered to be worthy of leaving behind in Fiona Trust are entirely equally applicable here. The purpose of Section 108 is a point that Learned Friend has referred to many times, in particular in relation to notions of cash flow. Now, well, it's certainly easy to point to, it's certainly possible to point to reports where you can see adjudication associated with contract cash flow or with cash flow. If you associate it with cash flow, the distinction between a going concern and a non-going concern becomes rather weaker in our submission, because cash flow is as important to a company in liquidation and its creditors as it is to an under-resourced subcontractor trying to stay alive in a difficult business. But it's also possible to see dispute resolution being treated as as a good thing and as a purpose of the Act, entirely separately from notions of cash flow. And one can see that in the Latham report, but one can also see it in the very short passage from a judgment of Lord Justice Coulson given at the end of last year, which we cited in our skeleton, where he identifies the two aspects of the Act which he regarded as being a great success. The first was the interim payments regime, which he associated with cash flow, and the second was dispute resolution process, which was entirely freestanding. But the critical point in our submission is that you're stuck with the words of section 108, and that was the point made very clearly by Lord Justice Dyson in Connex, which is Authorities Bundle 2 at 7.1. I'm sorry, you started with a paper bundle. It's page 714. And Lords, in this case, it was, if I can just, I think, pick up paragraph 34 of the judgment, page 724. And this is a post, so this is an adjudication sought to be started long after the contract had terminated. And it was submitted that it was an abusive process for the company to start adjudication proceedings so long after it purported to accept a repudiation of the contract. And Lord Justice Dyson sets out the words of the section, including and italicized at any time. And then you'll see the argument at 36, which is essentially that you can't take that literally. And what is, there's an extract from Hansard then cited, and then the submission, Parliament content for adjudication to take place after cessation, because this was seen in the context of a procedure which was quick, cheap and temporary. Once this quick, cheap and temporary decision be taken, it then followed by a permanent decision via arbitration of courts. But he argues that if as a result of the passage of time, no longer possible to have quick, cheap, temporary adjudication, then it's an abusive process to permit an adjudication to take place. But then the very short rebuttal is at 38. It means what it says. And similarly, and really it's the same point made in relation to, which can be made in relation to the points about cash flow. That's not, the section simply doesn't say it. You just take the section as it is. If it's clear as it is clear, then really that's the end of it. So that's on purpose. Then I'm looking through just some of the points. Sorry, I'm back to my learned friend's skeleton and taking each of the points. I think some of them I've dealt with, the need for a single and final account, not satisfied by adjudication. This is page 209 of the bundle. I'm looking at paragraph 64 of the skeleton. Lords, I think our submission on that is clear, that we've already characterised the nature of the insolvency process, and the proof process in particular. If one takes that as the comparator, which we suggest is the paradigm comparator, the differences between the proof process in insolvency and an adjudication, the process that takes place via an adjudication, are not. There are differences, but they're not particularly stark. And then if one looks, if I can just pick it up at the skeleton of paragraph 72, where there are then some numbered items. The inherent likelihood of error, that's paragraphs 72 and 73 of the skeleton. Now, it's now put as a high risk that adjudication decisions will contain errors. Now, I don't have any statistics which enable me to assess whether it's a high likelihood, a low likelihood, or any likelihood. What I'm prepared to accept, of course, is that there is inherent in the adjudication process a risk that you might get an inaccurate result, just as there is in the proof process. But one of the factors, and I agree that the more truncated the time period, there will undoubtedly be an increase in the risk, although it's in the hands of both parties to agree, if they think it's sensible, that it should be extended. A point particularly made, though, is in the identity, about the identity of an adjudicator. It won't be a lawyer. Well, really 2 points about that. The first is that exactly the same could be said about an insolvency practitioner undertaking the proof process. That's 3 points. The second is that, like insolvency practitioners, adjudicators have been around long enough to have gained sufficient experience to make up for sufficient experience to make up for to make up to some degree the fact that they are not lawyers. But the third and critical one is that both IPs and adjudicators have the power, in the case of adjudicators, expressly have the power to employ lawyers. And so if there is a problem, then they have the means of addressing it. So, Lords, disputes under multiple contracts, I think I've dealt with. One dispute at a time, paragraph 75, I think I've dealt with. Limitations on cross-claims. Lord, we have to some extent covered this, but can I just perhaps just add this? If we can just take a case where we are looking at a single contract with cross-claims. Now, primary submission is that in the normal case that should be possible. It should be possible to deal with that as essentially a sort of completion adjudication by a single adjudication. And one can see examples of the approaches to construction which say that and embrace the possibility. But as you can see from Cantillon, the passage that my learned friend referred to, again, but I think this time Mr. Justice Aikenhead, makes it clear that defences by way of set-off can always be raised. And so to the extent that it's not embraced within the, to the extent that the dispute is not already embraced, it's always opened for it to be raised by way of set-off. And as to the notion that it can't be reflected in the relief, Lord, the scheme itself gives the adjudicator the power, insofar as it's ordering payment, to order it each way. And so one would have thought by one means or another, a cross-claim, and certainly a cross-claim under the same contract, and possibly more, certainly under the same contract, ought to be capable of being dealt with. Lord, on the binding nature of adjudication, Lord, we simply say this: adjudication decisions they are binding, and they represent a final. They bind the parties when they are made, and they represent at that point, insofar as they've dealt with the account, a final statement of that account. That the adjudicator has done his job. He's arrived at a figure where he's dealing with set-off. He's given his determination, and that is the end of it, and it is binding. Of course, the Act says what it says about the nature of what it means by binding. It binds, until somebody else does something about it. Of course, that's right. But I think, as Lord Mance described it in aspect, nobody's compelled to go off to court or arbitration or whatever in order to get a final statement about a final statement about their respective rights and liabilities. They may, for many good reasons, not least because they don't disagree, or they think that because they don't disagree with the decision or think that it's more or less okay, simply not bother. And so it was for that reason, and because, as he acknowledged, Lord Mance acknowledged, many may be prepared to accept the compromise, that he characterized the binding nature as binding unless and until something else happened. And Lords, we respectfully submit that that is correct. And if one treats adjudication in that way, if you think about it in that way, and then compare it with the process that I've described, it's actually not dissimilar. In both cases, for various reasons, what's intended to be a final decision taken at the end of a process is capable of being revisited and reopened. Lords, I'm sorry, I'm just going to finish, and then I'm on to injunctions. I just want to deal with the position in other jurisdictions. And Milana Friend referred to, these are referred to the facade case. She referred to Victoria, particular to Victoria, New South Wales, and that's what I want to refer to as well. Lords, the facade case is at page, I lost it. Page 3046. Now, Lords, that's for your Lordship's reference, because the case that I want to concentrate, the case that I want to take your Lordship's to, which covers the same subject matter, is a decision of the New South Wales Supreme Court, which your Lordships will find now, hopefully, at page 3166. Now, Seymour White, as I said, it's a decision on the same subject matter, made subsequently, in which the New South Wales Supreme Court, and indeed the judge at first instance, disapproved facade on the basis that it was plainly wrong. Now, I think there are, I could probably summarize the points that one gets out of Seymour White in this way.
I beg your pardon. Could you just give me that reference again, please? I'm just having a bit of trouble tracking it down.
It should be 3166. It came into the bundles. We saw this case, and I think sent it to the registry Monday, I'm told.
Right. Beg your pardon. Let me have a look.
We don't seem to have got consecutive run-on pagination beyond the end of the pagination of the main bundle.
It's in a supplementary bundle for us, and it's numbered 3 up to 3166 at the bottom, but that doesn't correspond to the electronic numbers.
sorry, that's simply, it's immediately after an extract from Hansard, I think.
I've got it.
That helps.
If it's of any help to others who are still struggling, it's in what's called on my files the third supplementary bundle. And then if you go to the index, there's a link.
I'm grateful. Yes, I hadn't. I think I wasn't sure quite how it had got, how these supplemental documents were coming to you. Also, sorry, can I just I wasn't sure whether everyone had it. I'm being silent just simply because I'm not sure whether everybody has now got the authority.
Yes, I've got it now. Thank you very much.
Lords, I hope I can take this fairly quickly. But if your lordships will look at page 362 of the report, this sets out the relevant section, or one of the relevant sections of the Act, the one I want to refer you to. Now, the format of the Act, the structure of the Act is different, obviously different to the Construction Act here. And you'll see a reference to payment schedules. And the way it works is the claimant serves a payment claim on the respondent. You can see that 16.1. The respondent then has to respond with a payment schedule within a specified time. And it's the payment schedule which sets out the respondent's response to the payment claim, what it's prepared to pay, and what it's prepared to pay. And the section is engaged if the respondent fails to pay the scheduled amount, that is the amount in accordance with the schedule. And then if that happens, subsection 2, the claimant has two options. It can recover the unpaid portion as a debt due to the claimant in a court of competent jurisdiction, or make an adjudication application. And then shifting to 4, if the claimant commences proceedings under 2A1, then judgment isn't to be given unless the court's satisfied of the circumstances specified in subsection 1. And importantly, B, the respondent in those proceedings is not in those proceedings entitled to raise a cross-claim or bring any defence, to raise a cross-claim against the claimant or raise any defence in relation to matters arising under the contract. Now, these were not adjudication cases. These were cases where there was a failure to pay, and with a slight quirk in this case, that the claimant had tried to do both things, but had tried to recover as a debt and make an adjudication application. Both cases were concerned with recovery of the unpaid portion. And in that event, you can see that cross-claims are excluded by B. And so the first issue in both cases was who could be a claimant for the purposes, who could be the claimant for the purposes of these sections. In facade, I'm so sorry, I think we've lost Ms. Sinclair.
We better have a short adjournment while we try to sort this out, Mr. Arden. All I'm going to do is switch off my video feed and microphone in the meantime, and we can be contacted by our IT team once they once we have Ms. Sinclair up and running again.
My lord, there was an interruption to my connection. I can now see and hear you. Can you see and hear me?
Fine, that's excellent. How long were you out of touch with us?
Probably only about 5 seconds. There was just a dip in my connection for some reason.
That's fine.
Apologies for that, but happily it seems to have restored itself.
Not at all. In that case, we can return to Mr. Arden.
Well, Lords, I was just simply on section 16, and then I moved on just to identify the first issue, which was whether the claimants in these cases, or whether a company in liquidation could be a claimant for the purposes of these provisions. The Victoria Court had said no, because you had still to be undertaking construction operations to be a claimant, and a company in liquidation was not. And on that, the Supreme Court disagreed and said that was wrong. It was perfectly possible for a company in liquidation to be a claimant. The second point then arose about the compatibility of the provisions that I've just referred to, and in particular the provisions which excluded cross-claims, with the mutual set-off provisions in the Corporations Act. Lord, that then gives rise to an issue special to federal, to countries, federal countries like Australia, which is that the payment provisions legislation is state, and the Corporations Act is federal, and both in the run-up to the passing of the Corporations Act and since, there remains a tension between state legislation and federal legislation, and difficulties about compatibility and which trumps which. The Victoria Court held that the exclusion of the right to cross-claim was unconstitutional because it conflicted with the set-off provisions of the Federal Act. But it's true that it then went on to deal with the sorts of issues that the learned friend has referred to, relating to the interplay between insolvency, set-off, and enforcement. But as I said, it needs to bear in mind that this is in the context of an act which has sought to exclude set-off, which doesn't happen here. Now, the Supreme Court of New South Wales didn't have to deal with it. The constitutional position was not raised and therefore not decided. But if your lordships just go on to, in the bundle, the number in the numbering of the report 396, and then through to 255 with a summary at 256, what your lordships will see there is the court considering the interplay between the two sets of transactions, but the interplay, in fact, in circumstances where set-off has been excluded, which is rather more radical than the position that we have here. And you can see, and I'll take this very quickly and then just concentrate on just a few paragraphs. You can see that Guy and McIntyre is referred to, and other authorities. But then if one can pick it up at 253 to 255 in particular, what your lordships will see is the incompatibility, it's the problem of set-off, but that in that case, as I said, raised in a very radical form because it's being excluded, being dealt with not as a reason not to proceed, but as matters relevant to relevant to enforcement. And there's an interesting at 253 line 255. You'll see obviously later on there's references to stays and the like. But at 25 of line 25, there's also just raising the possibility that in fact you haven't destroyed there's no incompatibility because set-off would still apply between the judgment debt and the sum sought to be raised by way of a cross claim. So it's sort of by the by. It's just a sort of interesting footnote. But it's the approach in our submission is consistent with what we say, particularly what we say in relation to the next part of this appeal. Now, Learned Friend has referred to the position in New South Wales in her case, but referred to an amendment to the Act, which I think was made after the Seymour White case, or possibly in response to it, or possibly in response to the first instance decision, which simply now prevents or excludes companies in liquidation from the benefit of the provisions of that Act. Now, that doesn't really help the Learned Friend, because whilst that may now be the position in New South Wales, it is not the position here. The position here is that companies in liquidation, or any other form of insolvency process, are not excluded from the provisions of the adjudication process. And what the New South Wales experience suggests is that if they are to be, it needs to be done expressly. Lords, that's it on jurisdiction. And Lords, as I indicated, I think because I've dealt with a lot of the points already, I will take the injunction case reasonably quickly. I think I can take it fairly quickly. Lords, can I just ask the Lordships just to take up the judgment of the Court of Appeal, which is at page 243, and pick it up at 255, paragraph 31. Lords, in this part, he's dealing with, Lord Justice Coulson is dealing with jurisdiction. I just wanted to say one point about paragraph 31, which Learned Friend has rightly identifies as being rather potentially read one way, rather wide-ranging, in suggesting that rights, the underlying claims can continue to exist for all purposes, which would suggest that that set-off has no substantive effect at all, possibly. All I would say is this: that wasn't clearly it wasn't our submission in the Court of Appeal. It's not one, certainly not one that we make now. And I just wonder that if one reads this in context, whether actually, in fairness to Lord Justice Coulson, what he's really saying is that for all purposes, in other words, it's a reference to litigation, arbitration, and adjudication. So what he's making is the point that they're treated as continuing to exist so as to provide the necessary jurisdiction for all purposes where jurisdiction is required. I mean, that might be a slightly awkward way of putting the point, but that's the point I'm trying to make. Well, can I just ask the Lordships, though, then to note paragraphs 32, but then particularly 33. This is really dealing with a point that was made about the non-binding nature of adjudication and its relevance in the context of jurisdiction. And just the argument overlooks the fact that although the result of adjudication is not usually final, it may be final or may become final. And then he identifies the various ways in which that could be. So the parties go away and they are content with the decision or not discontent enough to want to do anything about it. What he then addresses is the point that you can't test jurisdiction by reference to finality because you don't know whether it's final or not till you've got to the end and know what parties are going to do about it. Lord, that's a sound point. Lord, that's a sound point, but it applies as much to jurisdiction, as much to the injunction part of this case as it does to jurisdiction. I'll come back to that in a moment. Now, Lord, the injunction part of the case then starts at 37. And although it's treated under the general heading, basic incompatibility of adjudication and insolvency, I think on analysis, and I say so with great respect, there is more than one. There are more than one set of factors at play here. There is the point that's identified in 37, which is the basic incompatibility point. There is then, and that is then carried through in his comments on process. So 37 to 42 is the two processes are fundamentally incompatible. But then B at 43 onwards or B particularly, 43 to 46 is not about incompatibility, that's about utility or futility. And that all turns on enforcement. And then there are, separately from that, the wider considerations at 47 onwards, which are cost-based. So they're cost-based considerations, which include not only the costs of the responding party, the costs of the adjudication and any further proceedings, but also the suggestion at 48 that it's a waste of the liquidator's cost, the waste of the limited costs of the estate for the liquidator to take that course. Now, can I just, so having identified, so there are three different areas that one needs to look at, and I think they do need to be treated separately. Now, before I do that, can I just indicate where we stand on the tests to be applied? Now, I'm sorry, I just we have suggested that there are, in a sense, there are two aspects of what we've described as the what we've treated compendiously as the anti-suit injunction, that there are two aspects of this in play. So far as incompatibility is concerned, there you are dealing with the issues that were considered by the Privy Council, I think, in the Shell Pension Fund case. And that is it's an audit, and I think is described. It's the foundation for an injunction of uncertain scope. Although I think that probably applies to this injunction in these circumstances generally. But it's testing a step taken usually by a creditor. I can't for the moment think of one taken by a liquidator, but usually by a creditor. A step taken, for example, often by way of attempts to enforce overseas, try and get an advantage over the general body of creditors by some form of process or other. But it's usually testing that or characterizing that step as in some way incompatible with and undermining the statutory scheme which the Act imposes and the principles which govern it. That's and so that we would say is that's the first part of the injunction jurisdiction which is relevant here. And we've referred to the Shell Pension Fund case. There is an analysis of the circumstances in which injunctions will be granted, and unsurprisingly, they're limited. But in what I've said quite shortly, I hope that I've encapsulated the position. Lords, it's 1 o'clock. I'm not far off because I think that most of what I'm about to say, I need shortly to deal with the two cases that govern two cases which govern other aspects of this. And then I will make some fairly short points on jurisdiction. So I think I'm going to overrun probably by about 20 minutes. But I accept the penalty, obviously accept the penalty, but I think it's any submissions that I would have at the end are going to be very short anyway, because there will be very few, I suspect, that will be properly open to me.
Yes. Yes, very well then. We can simply take any overrun off your reply time. Well, in the meantime then, we'll adjourn and sit again at 2 o'clock.